My turn to touch on some of the case law. So it'll be actually a year coming up next month in March that COVID has been upon us, and many of us have had restrictions. But in some cases, we're only now seeing decisions come out involving COVID. All right, so the first case is Caressant Care Nursing and Retirement Homes versus Christian Labour Association of Canada. This is a case out of Ontario that dealt with mandatory testing of healthcare workers in a nursing home setting. There were no positive cases of COVID-19 during the period that was in issue in the arbitration. So just in terms of analysis, the arbitrator used drug and alcohol testing cases as a starting point. The reason being is that involves a balancing of the employer's business interest and safety concerns on the one hand with employees' privacy rights and rights to the integrity of their person. However, that's sort of where the analysis stopped in some sense, because the arbitrator found some significant differences between intoxication in the workplace and COVID, noting that intoxicants such as alcohol or drugs are not infectious as COVID is. And so in that context, the weight to be given to the privacy breach was lower, given that the employer's concern here for the residents of the nursing home was more significant. That meant that the privacy interest was not as significant as normally would be the case. And this was, another factor, I guess, that contributed to that weighing is that public authorities were still learning about COVID at the time, and to some extent, with variants now out there, that's still an issue.
We had major changes in the Labor Relations Code, which were brought in through Bill 32, the Restoring Balance in Alberta's Workplace Act, which has been described as an employer-friendly act. We also had significant changes under the CanLII Labor Code through the bringing in of the Workplace Harassment and Violence Prevention Regulations. These are now effective January 1st of this year. So this applies to all federally regulated employers, and what it does is it replaces the provisions that were in existence under the occupational health and safety regulations under the code. The provisions, while this only applies to federally regulated employers, provincially regulated employers need to pay attention and be aware of these changes because they are so significant and so different than what we have in place that we can certainly anticipate that these changes, could work their way into provincial legislation.